Joining us here and now on the Vicki McKenna Show on the Middleton Ford Hotline, family-owned and your good neighbor Ford dealership for nearly 75 years, Nathalie Burmeister, Associate Attorney at the Wisconsin Institute for Law and Liberty. Welcome to the show. Thank you for being here.
Thank you. Thank you for having me.
This was an interesting decision, not unexpected from those who have been watching. Interesting timing coming on the Friday after the 4th of July holiday when a lot of people weren't looking. Certainly caught the national press's attention. But this was an issue that the Wisconsin Institute for Law and Liberty was involved in early on with the lawsuit. You were successful in that lawsuit, and I would argue that you were successful because you argued on the law itself, which clearly states you cannot operate these kind of unmanned drop boxes in the state of Wisconsin. Were you surprised at all by the ruling?
Well, you are correct, yes. 2 years ago, the Wisconsin Institute for Law and Liberty litigated a case which argued that drop boxes, unstaffed drop boxes, are not authorized under Wisconsin law. And Friday's decision comes 2 years later, and we're disappointed in the outcome because we believe that the original case from 2 years ago was correct on the law. Again, 2 years ago, a majority of the court decided that drop boxes were not allowed under Wisconsin law. But since then, the composition of the court has changed such that the minority in the case from 2 years ago is now the majority. A new case on that issue was filed, and now we have a new interpretation of the law as of Friday that overturns our prior decision.
This is what the majority, again, the liberal-controlled majority, the court's liberal majority wrote. They control the court 4-3. Our decision today does not force or require that any municipal clerks use drop boxes. It merely acknowledges what state statute has always meant, that clerks may lawfully utilize secure drop boxes in an exercise of their statutorily conferred discretion. That is not what the state law says, at least by my estimation, and it certainly doesn't say that by any, I think, reasonable reading of the law. And the Wisconsin Institute for Law and Liberty made that case, I think, successfully a couple of years ago, and made that case again before a previous Supreme Court. How do they see this as this is what the law meant?
Yes, well, we did argue that at both in the case from 2 years ago and then in our friend of the court brief that we filed in this case to let the court know that our position is that we were right on the law in the case from 2 years ago and that they should not have overturned it. That interpretation from the majority opinion is their interpretation, but as you mentioned, our argument is that there is no mention of drop boxes in any of the statutes which are designed to carefully regulate absentee voting. And so our position is that because they are not mentioned and because the statute itself states that absentee ballots must be returned either to the office of the municipal clerk or a designated alternate site or to be mailed as the Tigan court held, that is the correct interpretation of the law. Again, Friday's decision is not consistent with our interpretation, and we maintain that our interpretation, as the majority of the court concluded 2 years ago, is the correct interpretation of the law.
Tigan is, of course, the name of the case that was taken up before lower court and then ultimately before the Supreme Court. The conservative-led Supreme Court in 2022 ultimately upheld the lower court decision that said the law is clear. As a matter of fact, this is not just Will's position on this. This was the majority opinion in 2022 that was written by, I believe, the finest jurist on that court. But that's just a personal sentiment of mine, Justice Rebecca Bradley, who wrote, "Only the legislature may permit absentee voting via ballot drop boxes. WEC, the Wisconsin Elections Commission, cannot. Ballot, and that's what was at stake here, because you had WEC once again going around the rules during COVID under the cover of COVID saying, yeah, you can use as many of these unmanned drop boxes as you want. That's how we interpret the law. Bradley goes on to write, ballot drop boxes appear nowhere in the detailed statutory system for absentee voting. WEC's authorization of ballot drop boxes was unlawful. And Justice Bradley, mincing no words in her dissent in Friday's ruling, said that the majority forsakes the rule of law in an attempt to advance its political agenda. Do you agree?
Well, unfortunately, the decision, like we mentioned, did not come out in the way that we view the interpretation of the law should be. And, our position is that whether or not you support the use of drop boxes, the choice to use them is a policy decision that, as you mentioned, should be left up to the legislature, not the judicial branch. And so we believe, again, that the law should be followed according to what it says, and as written, the law does not provide for them. And so we have argued and did argue in our amicus brief that such a decision to authorize it without an explicit mention, and in light of the statutory interpretation that took place by a majority of this court 2 years ago, that drop boxes are not authorized, and that the decision to do so is therefore a policy choice that should be left up to the legislature, but then has been implemented by the judicial branch in this instant action.
What can be done by will? That is, first and foremost, does the Wisconsin Institute for Law and Liberty intend to appeal? Can it appeal? Where would it appeal? What can be done in the face of this ruling by the state Supreme Court?
Sure. Well, the first thing is that Will was not a party to this case, that we didn't have clients as a party to this current action. We participated on behalf of a few clients as a friend of the court in this action. So in terms of this actual case, there wouldn't be anything that we could do in terms of appealing from the decision on Friday. And the important thing to remember here is, as far as the impact of this decision, we are weeks, if not months, away from this decision being implemented. And so at this time, I don't have anything to speak of regarding whether or what future legal action we may consider taking. But as a reminder, we are always here to answer questions that people may have. For example, we have a contact a lawyer form on our website at will-law.org, and those who are requesting legal assistance can certainly fill out our contact a lawyer form there. And those who are interested can always sign up for updates as well at will-law.org. But in terms of how much more involved Will may end up getting at this point remains to be seen. But we will definitely be monitoring and considering our legal options as always moving forward.
All right, that's a good point. I mean, you are not a litigant in this particular case. You were a litigant in the original case, in the one that appeared before the Supreme Court in 2022. So you don't have, in essence, a mechanism without bringing something original here. That said, what can those concerned about what this will mean, and certainly those concerned about what they witnessed in 2020 with the proliferation of these drop boxes across the state, what can they do? What can be done in the wake of this Supreme Court decision?
Yes, definitely. And at this time, I mean, the decision, again, just came out on Friday. And so we're monitoring. And if there are people with specific questions or concerns related to anything about this decision, they should certainly feel free to contact us through our website and let us know what concerns they may have. And at this time, as I said, we'll be monitoring the situation and considering our legal options. But at this time, we aren't going to get into specifics about what any potential lawsuit may look like, just because we're monitoring it and thinking about, what does the future hold in terms of what legal action may be able to be taken moving forward here.
Final question for you, Nathalie. It's interesting to me in this case, because I look back at what happened in 2020, and there were a number of cases before courts before the election, and certainly many more after the election. And I kept hearing from the courts, whether it be the lower courts in Wisconsin, the Supreme Court, a conservative-led court at that time, the argument from Democrats, from the left, and ultimately answered by the courts, came down to it's too late in the process, too late in the game to change anything. That would confuse the voters. That would be disastrous for the clerks. we're very close to a primary election, and we're not that far away from a general election. Doesn't this go against that kind of argument that we heard over and over again in 2020, what the state Supreme Court just did on Friday?
Well, you are correct that there is some case law, as you mentioned, that discusses the timing of bringing election-related challenges. Sometimes it's too soon, sometimes it's too late. In this instance, I guess we're currently not sure if this is something that is either too close to an upcoming election or not at this point. Again, it's a decision that was just rendered on Friday, so we'll take a look at everything and monitor it as it moves forward. But for sure, those are good points about the timing of the decision as well, and that's something that we will keep in mind as things progress moving forward.
All right. I appreciate your time. This definitely was a shock to election integrity. I think it will have troubling implications for election integrity moving forward as we get ever closer to a critical election in a critical swing state. But as you said, we will see. Nathalie Burmeister, Associate Attorney at the Wisconsin Institute for Law and Liberty, joining us on the Vicki McKenna Show. I appreciate your time.